action. Okay.
I'm not taking any chances today. I turned the camera on myself. Everybody hate me? Did we do okay?
I don't know, I felt that test.
All love.
Well, we'll see when you give us
You failed that test,
Let's go over it.
What's that?
I would like to.
No, we're not going over the answers. Maybe next week. Maybe not. Why would you want to go over the answers?
So I can know what I got right.
All the ones that were correct, you got right. Okay.
Can cannabis be by the pizza shop?
Say that?
Cannabis can be by the pizza shop, right?
Don't you think the pizza shop would like that?
A treatment center?
I know they would like it.
Come on!
That's a good one, that's a really good one, yeah.
Of course they would like it, but I'm just making sure.
A cannabis treatment
Why
facility?
wouldn't it be?
What do you mean, you're
I
treating
know
folks?
the reason I said that.
It's not a treatment
it's
center.
false.
That's what it said. It said cannabis treatment facility.
What?
Did it not?
Yeah, that's what
It
it
said treatment facility.
Whoa, I didn't know.
Like where you're curing plants and you're, I don't know, whatever you do as a.
There's no reason why it couldn't be.
There is
That's
no
the answer.
It's the best thing for the monkeys.
See how they twist that around?
That was my point.
Yeah, it's the best thing for the
That was
monkeys.
my point. I told you the worst part about working. Actually, Tuesday we're having a big conference in my office. The worst part about working in that area is the jokes. You really can't because it's been a hidden business for so many years, and people just make jokes about it. No, you never ever thought you would see something like that come into the light and be legitimate, like it is so much. I mean, people investing huge amounts of money, making huge amounts of money, and it's almost legal. Just remember that, almost.
Almost.
All right. So today, and I don't have the outline up at the moment because I have a document up, but you all have the outline, and I'll bounce back to it when we're not looking at documents if you like, if you find that it's helpful to have the outline up. And today I want to talk about real estate litigation. And the first thing I'm going to talk about is mortgage foreclosures. And mortgage foreclosures and workouts I want to add, because we do try, even representing the banks, to work out the problems when someone can't pay. And the banks prefer that because, when you think about it, the banks are not in the business of owning real estate. If the bank forecloses a mortgage and takes the property back, the first thing they're going to do is try and get rid of it. They want to get rid of it. They don't want to own it. It's not as productive an it's not their business. As you probably understand, owning real estate and operating real estate takes expenses and it takes people. And that's not what they do. They do have something called an REO, or real estate owned department, to manage the assets when they take it back, but it's designed to be short term, except in a really bad downturn where they can't get rid of it. So, let me talk a little bit about the mechanics of a mortgage foreclosure and what's involved in it. And the most basic thing I want to tell you, people forget this when they're talking about foreclosures, but a mortgage foreclosure is a title transaction. Just like buying a piece of property or having a deed, it's a title transaction. You are, through the court system, taking property that is owned by one party and taking it away from it, so at the end of the process it's owned by a different party. It's a title transfer, which means you have to worry about things like subordinate liens, which means you have to do a title examination. So you start your mortgage foreclosure process with an examination of title, just as you would for a purchase, because you need to know what the problems are. Now, we haven't really talked much about recording priority, except for the basic question, which hopefully you all recognized: first in time, first in right. Because I talked about that, and it's got a nice ring to it, and it's fairly easy, and that's why it was one of the questions. So, and if you didn't get it right, I'm sorry. So, when you're foreclosing a mortgage, think about it that you can only foreclose downward, which means you can only foreclose interests that have come about after the mortgage has come about, because anything prior to the mortgage is superior to the mortgage. with one two very narrow exceptions. And the other thing that I think was also on the exam is real estate taxes. Real estate taxes is the state. The state always comes first. But other than that, there is a device called the subordination agreement by which you can alter the recorded priorities by contract between the parties. That would happen if, for example, you had a mortgage on your property, and it was a small mortgage, and you went to the bank to get a new mortgage. And the bank said, okay, I see you have a mortgage in favor of your seller, for example, but if we're going to loan you more money so that you can renovate or whatever it is, we have to be in first position. So you, the owner, the bank, and the person holding the second mortgage sign a contract called a subordination agreement and agree that the bank comes first. Even though they are later in time, the agreement alters the recording priorities. Absent that, now that you do your title examination and you find out that somebody had hurricane windows put in and they didn't pay for the hurricane windows and the contractor recorded a lien on the property. Because now when you're in a mortgage foreclosure, things are starting to go south, meaning you're not making your payments to the bank, you're not making your payments to other people. So in doing the title examination, you see a lien that comes about after the mortgage has been recorded. And as part of the process, you want to join this subordinate party in the foreclosure to wipe out their interest. We'll talk about how you do that in a minute. You also want to eliminate the rights of anybody who has possession of the property. If it's an owner-occupied, that's easy because you're going to name your property owner and you're going to join them, and when they're done, you're going to get possession. But if it's a rental property, which is very often the case when you're dealing with foreclosures of investment property, because when the economy goes bad, I've been through this twice in my career, when the economy goes bad, what you find is people are not walking away from the house they live in. People are walking away from those 3 houses that they bought with 3% down because it was a really good investment and a great return on money, and they were going to get rich flipping houses, and the market has turned, and now the mortgage is greater than the value of the property, and they walk away. And that's what generates the foreclosure issues. So there you have to foreclose not only the person that owns it, you have to foreclose any liens like the hurricane windows, and you have to extinguish the rights of the tenants in possession. And you're going to see in a minute when we go through the complaint how that's all done. Also, when you are working through the title work, if you see title issues, you might see that somebody has some interest in the property pop up that they shouldn't have. Maybe it's a wild deed, maybe it's an improperly recorded easement, something like that, some issue that has occurred after the mortgage. You can join and extinguish the rights of that party to clear the title issues out. So, how do you start a mortgage foreclosure? The same way you start every other bit of litigation, with a complaint. The complaint, which I'm going to show you the guts of the complaint to foreclose in a minute, but a complaint is the starting of, forget demand letters and things like that. You start with a complaint. And what the complaint does is, the complaint sets forth facts. Facts which are sufficient to establish a cause of action. You start off very basically, and forgive the names, I just didn't know what else to do with this to get rid of real names. So you start off by alleging what you're doing. And you say, this is an action to foreclose mortgage on real property in Broward County. Now, in fancier litigation where you do not have humans, you might have a recitation saying that ABC LLC is a limited liability company formed under the laws of the state of Florida, with offices in Broward County or some nonsense like that to establish who you're suing and why you're suing them. So here we're going to eliminate that. I'm going to go right into the facts of the case, basically, and you're laying out the facts, just the facts of the complaint, to establish why you were entitled to foreclose the mortgage. And it starts out in a real simple recitation. Hopefully, again, remember, promissory note is the root of everything. Hopefully you all got that one right. And you, again,
What was that?
the promissory note. Remember the mortgage follows the note? You all got that right? Right? Good.
Maybe.
So you start off by saying that a note was signed. Then you say to secure the note, we gave a mortgage. And what did we give a mortgage on? And you recite the legal description of the property, because remember I said it's a title transaction, so this is going to get picked up in the public records. Also, what's going to go into the public records is a notice that you filed a foreclosure, because this goes into the court file. But you want to put up a notice in the public records, and it's called a notice of lis pendens, which are L-I-S, 2 words, P-E-N-D-E-S, lis pendens. And that is just a notice of a pending action. And you put that there to establish a date. It's actually almost a gate that goes up and says, as of this date, we have filed this foreclosure action. And anybody that acquires an interest in this property after this notice is filed is subject to this foreclosure. And the purpose of that is to give record notice of it, and more importantly, so that the plaintiff and the plaintiff's counsel doesn't have to keep going back over and over and over and bringing in new parties as they acquire additional interests. Because you'd be surprised what people do during the foreclosure when it's really bad, trying to preserve your investment property. They start conveying it to third parties, they convey it to multiple parties, they file stalling motions, they do all kinds of things because there's rent coming in. And the longer they can stall it, the more rent that's going to go in their pockets. Okay. You recite the plaintiff owns the note, you recite that they weren't making payments, or what else they've done. 6 is a different kind of default, a non-monetary default, but it also recites that in addition to the fact that the defendant failed to maintain insurance, the plaintiff, in order to protect the property from being lost in a storm, laid out money for insurance, so they're entitled to that back. And of course, number 7 is what gives rise to the right to collect. We've accelerated the debt. They have demanded the full amount because they haven't paid them. That's their remedy. Now you go into the amount, which is whatever the current amount of the mortgage is plus the expenses. In paragraph 9, you recite who the owner is or owners. 10 gives you the right to attorney's fees. Now, 11 is a generic provision that would normally be replaced here by a recitation of who else owns a subordinate lien. So if you had the window contractor or you had a second mortgage, you would throw things in there, you put paragraphs in there reciting specifically what those subordinate interests were and what instruments gave rise to those interests, and you would have a recitation that they are subordinate or inferior to the lien of the plaintiff's mortgage. Now, this is 11, what I have here is a generic statement, and it's usually used when you have a John Smith defendant, where you go and you do a title search, and the name is such a common name that there are so many possible people with the same name that you cannot determine who has an interest in this property specifically. So you put a generic phrase in there, and sometimes you might publish a notice. You're trying to clear everybody, clear the title of all of that. And then you make the demand to foreclose. Oh, there's a notice of lis pendens. That's what it looks like. So it basically says, but you're notified. That's all you have to do. You put the legal description in it. Anybody that recognizes that address gets extra credit. And nobody, not one, huh? Pay attention. Last chance. No? Okay. Now you want to know what it is, don't you?
Of course.
Mary Poppins. Actually, it's actually a blend. I don't think that was. I think that was Cherry Tree Lane. I think Mockingbird Lane is where the Adams family lives, and that would be 13. So that is not materially responsible for this crazy. That's what happens when you have children. Then you know things like that. Okay,
I said you go crazy when you have children.
Insanity is hereditary. You get it from your children. So. This is what the final judgment of foreclosure looks like. And this is what I didn't bother, the bank name, or it's old stuff. So basically what happens is, this is signed by the judge. And this says, after you provide all the proof through the course of the litigation, the judgment says how much is due. I promise you when you submit it to the court, it's formatted better than what you see on the screen. It recites that the bank has superior title to this property. And then it says in paragraph 3, now this is what's changed here dramatically. It used to say that it would be sold, okay, historically, what you would hear in the old days of foreclosure, it's going to be sold on the courthouse steps. And that really was what happened was the clerk would conduct an auction on the courthouse steps, and they would recite what was being sold, they'd have a list of sales for the day, they'd get up there one at a time, they would auction it off. The problem in Broward County is a little different. Anybody?
There's no steps at the courthouse?
Correct. Thank you. Ever since 3 courthouses ago, there are no steps. Before they tore the one building down a few years back, somebody told me that, you know, on the 2nd floor when you go into that snack bar and you go down, those were the steps. And they were actually at the corner of the 2 streets, and those were the courthouse steps. If you look at old southern courthouses or old courthouses around the country, you will find there's the courthouse steps, and so that's what they used to do. Here we are in 2020, and not only are there no steps, but now you will log on at any time to a website called Real Foreclose, and you can find the auctions. And you can bid at the auctions. And that, of course, screws the auctions up, because people bid without having any intention of going past a small amount of money. We'll talk about why. Well, no, I'll talk about it right now. So, remember I said it's a title transaction. So at the end of the process, after the foreclosure and after the sale, the clerk of the court issues a certificate of title. It's like a deed coming from the clerk, and it's subject to documentary stamp tax based upon the amount of the bid. So, the bank or other plaintiff has the right to what's called a credit bid. They're due the amount of money, let's say $1 million. So the bank has the right to bid up to $1 million because that's what they're owed. If somebody bids $1 million, $1,000,001, and the bank is silent, the higher bidder pays the $1,000,001, the $1 million goes to the bank, and it's over. The $1 gets distributed to whoever's next in line in the case. The problem for the bank is they always start at $100. At $100, you're only paying minimum dock stamps, which is $7. It's $7 per hundred. Yeah, okay.
Yeah.
70 cents. It's really 70 cents per hundred, but yeah, it's 70 cents per hundred. So it's 70 cents at $100. Sorry. As soon as they start bidding, you start paying more dock stamps. So when you get somebody that's logged on to Real Foreclose and they bid $80,000 for this $1 million piece of property, the bank instructs the people doing the sale for them, just go to the amount of the judgment. So as soon as that $80,000, because they don't want to waste the time because they're doing a lot of them. So the $80,000 bid makes them bid $1 million, which means they're paying huge amounts of dock stamps. That's a problem. I mean, it's a minor problem. It's a practical matter. When I was doing the foreclosures for a few years, it was physically in the lobby of the Broward County Courthouse, behind one of the escalators. And they would come out with the clerk would come out with their files and a podium on wheels and a microphone, and they would conduct the sales. And that's how it was done. People would bid or not bid. Okay.
Professor, question.
Yes.
So, in the case that the person who's foreclosing on this property, let's say Arizona wants to buy it back or wants to, repossess the property.
Okay.
Does that person have the opportunity to bid or go to the courthouse?
That person, the person who wait a minute, you're talking about the owner of the property or the bank?
The owner of the property.
The owner of the property only has to pay off the judgment.
Okay.
Until that last process is finished, the owner of the property still owns the property. There's this looming foreclosure action on them, but the reason for the foreclosure action is that they haven't paid the bank.
Mm-hmm.
All you have to do is write a check and pay the bank if you have the money. And you can stop it at any time in the process.
But if it gets to court?
Until that certificate of title, you can still pay it off.
Even they give you a certificate of title 3 days after winning the auction, after the debt. They have like pennies and sessions.
10, and it's not a rescission. That is not true.
Is it?
No. There's no right of rescission in foreclosure. This is a court case. You have 10 days between the date of sale and the date of the certificate of title for people to file objections. The 3-day right of rescission does not apply at all in this matter.
Okay, so and then the 10 days, because I know when I won them before, it took me like 15 days before I get my certificate of title.
Correct.
I paid the court.
Correct.
So that 10-day waiting period is because I was told that the seller could come back and pay off the judgment or something like that.
Is a right of redemption, yes.
The right of redemption, that's what I was looking for.
Yes. Okay? So, let me talk about the process. Oh, let me just finish a couple things on the complaint. So, it then says, after the certificate of title, after the process is done, then you can go back to the court and get a writ to throw out anybody that's in there. Further, if you go back a little further, well, it's in here somewhere, but what happens is, let's say the property sells, the $1 million property is only worth $750,000. And it either goes back to the bank or it sells to a third party. And the bank gets an appraisal and determines that the property is only worth $750,000 as of the time of the foreclosure sale. Why? Because as happened in the last recession, the value of the property went down, and it went down below the amount of the mortgage. The person that signed that I promise to pay, the borrower who signed the note, is obligated for the difference between what the collateral is worth at the time of the foreclosure sale and what they promised to pay. That's called a deficiency, because the collateral is not sufficient, or in this case it is deficient. It's not enough to pay back the debt. And remember, while the mortgage is there to help to secure the note is the primary document, and the note contains those magic words, I promise to pay. It's easy. All right. That takes care of the foreclosure and of the judgment. Now I want to go back to the outline a little, because I think it may be helpful.
No, go on.
Go ahead,
That's
question.
a question. Oh, actually, a question. First.
Okay, so now, what happens in the foreclosure, or this is any litigation procedure. So you have the complaint. I showed you the complaint for foreclosure. It could be the same thing if it's a complaint for eviction, complaint for money damage, any kind of a complaint that starts a lawsuit gets filed. Then you have to serve the complaint. You have to bring the defendant in front of the jurisdiction of the court. How do you do that? Well, there's three different ways to do it. One is personal service. The summons is issued by the court, it's handed to the sheriff goes out, and says, good afternoon, I'm the sheriff, who are you? You tell me your name, look at the paper, boom, you're served, just like on TV. I mean, that's it. That's it. They confirm who they're serving. Because I serve as a registered agent for corporations, I've been served many times. It's not a big deal, unless you're an individual lying at home and you get served with a foreclosure complaint. That's going to shake you up a little bit. One time I was served as a witness in a federal case, and when the deputy sheriffs come, it's usually private prosecutor, they show you a little badge. The federal marshals have a much larger badge, and it's very frightening looking. So, that's personal service. You need personal service to get a money judgment. In order to get money from a person, you have to touch them in one of two ways. The other way is called substitute service. I come to your house to serve you, and you're not home. But your wife answers the door. And she says, no, he's not home, I'm his wife. Boom, hands the service process. It can be to a spouse or to any person 15 years of age or older residing at the residence.
I seen someone get
Right.
on Halloween.
And so it's not necessarily required that they answer the door. And by the way, it can't just be anybody that answers the door. They have to be residing there. They have to be residing there. That's the law.
That's between the person that's handing the paper and the person that's saying that they serve you. They don't know that.
Right. Well, it's a question. Like anything else in litigation, it's a question of proof as to who's been served. So that's substitute service. And substitute service counts as personal service and it can give rise to a money judgment.
Well, wait a minute. So somebody delivers it to my house, and say somebody was just staying there, the dog's babysitting, and I'm sure they took the kids, right? And I come home and I do the dog's babysitting, and I shred it. I've never been served.
Probably. You'll have a fight on your hands as to who the person was and were they there for how long. And
So that if I call my attorney and tell my attorney I just got served and she answers it, that means I admitted that I got served.
if you file a responsive pleading, yes, you are subjecting yourself to the, and they're going to get you sooner or later, so it doesn't, honestly,
I'm trying to find
I
it.
mean, really, the reality of it is,
somebody from suing you.
the reality of it, you can try that. I may have told you the first week, I may have told you the story about the legal description of the lake,
Yeah.
okay? And one of the neighbors who happened to be in a physician was hiding in his house, peering out of the second-story window. Now, in addition to the sheriff coming, there are private process servers you can hire. And you pay them a little bit more, and you get much better service because the sheriff goes, they knock on the door, you're not there. The fact that it's 3 o'clock in the afternoon when no one's home anyway, they don't care. No service, they throw the papers back, and you gotta pay again and sit down. The private process server will dog you, and will you know, just like, again, I hate to say this, but just like on TV,
Pineapple Express.
they're gonna hunt you down. They're going to hunt you down, they're going to find out when you're there or where you are. And by the way, if they know where you work, and they can touch you with the process at work, that's perfectly fine. If they happen to see you at a football game, and they know you and you identify yourself, or they can identify you, boom, you're served. It doesn't have to be in your house. So, you can hide, but you can't. They're going to get you. Okay, so, now, you get served, and you go to your lawyer. And you look at this complaint and you go, wait a minute. There aren't enough facts in this complaint. It's like a so what? Okay, I did this, but I didn't do this, and they can't prove it. And they didn't put enough facts in here to show. For example, they forgot to allege that they hold the note, or they forgot to allege that there was a note signed, or something like that. Now you file what's called a motion to dismiss.
What about the constructive part, the third part?
Oh, I'm sorry, thank you. Sorry. The constructive service can really only be used if you're going for a non-money. For example, the subordinate lien holders, all you're trying to do is wipe their interest out in the property, my foreclosure complaint. A quiet title action, all you're trying to do is extinguish some interests that's out there. Constructive notice can be by publication. That means you literally publish a notice in the newspaper. The prerequisite to it is that you have to do what's called a diligent search and inquiry. Those are words right out of the statute. A diligent search and inquiry to find the person. And if you either can't find them or find that they're not within the state of Florida, then you can publish and you mail them a copy. That's constructive, where they're supposed to get it. Now, in some cases, it's an absolute fiction. But the law says, look, you got to get down the road, and if you're going to hide yourself somewhere, because one of the qualifications for constructive is someone who's either outside the state or they conceal themselves from service. Okay? Which, in your case, if we're trying to foreclose your mortgage and we don't care about getting a money judgment, you can do the constructive. It's only when you want that deficiency that you need to touch somebody. So we're going to get you. Just one way or another. Companies can appoint, well, companies have to appoint an agent for service of process. First of all, a corporation, for example, and probably other entities as well, are required to maintain a business office in the state and have it open for certain hours. They're also required to nominate somebody in their state filing to be their agent for service of process. So if you have a small LLC, for example, and you don't have an office because you're either here or you're out flipping properties and you're not sitting there, you have your lawyer or some private company that does this as your registered agent. That's the words, registered agent for the corporation, and they're the ones that get served. And that's done all the time. We do it for our clients, really, because if we get it and we call the client and say, hey, we've been served on your behalf, do you want us to do anything? It's much easier for them to hire us to handle the case.
Is there an advantage using a registered agent as against, you know?
The agent yourself?
Right.
Well, because if you are your own registered agent, you have to maintain an office and have that office open minimum hours during the day by the statute.
Okay.
If you're sitting in an office anyway, if that's what your business is and you're there, that's fine, there's nothing wrong with it. But if you're not going to do that and you're not operating a physical office, you have to have somebody where they can serve you.
Even if it's a one-person operation, what they call a disregarding entity?
If it's an entity, you have to have someone that can be served. Okay?
Because they always gotta serve, like your business, they always gotta serve.
Okay, so something's wrong with the complaint. There aren't enough facts. You have a motion to dismiss that gets heard before the court. The court says, the court looks at it, they argue back and forth, and the court makes a decision, either the complaint is sufficient or it's not. Almost 10 times out of 10, I can't even think of a reason why this wouldn't happen. If it gets dismissed, on the motion to dismiss, the court gives the plaintiff another chance to refile, leave to amend the complaint. Go fix it. Assuming you get past the motion to dismiss, and there is still, the next pleading, the responsive pleading is called an answer. And it's literally, you go through the same numbering as it's in the complaint, and you answer each of the allegations. Admitted or denied. Very easy. I'm a resident of Broward County. Admitted or denied. I mean, it's people that deny that are just ornery. There's no reason to. I signed the promissory note. Denied. You prove I signed the promissory note. I signed the mortgage. Denied. You prove it. Okay, so what I'm doing is, by denying it, I'm putting the burden of proof on the plaintiff. And the same thing with the rest of the allegations. Now, the other thing that you could have in that same responsive pleading is called affirmative defenses. Affirmative defenses, for example, the mortgage foreclosure. I paid it. The foreclosure complaint alleges that the defendant failed to make the payments. Defense says, I made the payments. Here's my proof I made the payments. He screwed up with his accounting. I have a defense. And that's an affirmative defense. Another affirmative defense, rare. He didn't give me any money. We've signed all these papers, he never funded the loan. I don't owe him anything. Those kinds of things. Okay, now we get past, we have the answer is filed, the complaint is filed, the answer is filed, the motions are disposed of. I'm not going to get into all the other discovery issues, because in complex litigation, you go back and forth with discovery, you bring in witnesses and depose them, you do requests for production of documents, there's all kinds of things. Again, that's the building next door. So, but the next thing that happens is you want to go get in front of the judge and have this decided. And there are two ways to do it. There's a bunch of ways. We're not going to talk about a trial, because in a foreclosure case, you don't usually have a trial. Usually there's not a whole lot to argue about. So, you have a complaint, you have an answer, everything's in there. We file affidavits, so we file what's called a motion for summary judgment. And a motion for summary judgment says, assuming that all the facts have been proven that are in our complaint, then the plaintiff's entitled to a judgment as a matter of law. So simple. What happens is you go in there with affidavits of the plaintiff or the bank. You attach the original promissory note, so there's proof there's a note. You attach the original mortgage, there's proof there's a mortgage. You have an affidavit of the bank that says this is how much is due under the note and mortgage, and it's been unpaid, and there are all the facts you need for that complaint. And you're done.
So the facts have been verified.
You're proving them. The defendant has the ability to file a counter affidavit as to any of the facts, but they have to be true. So, for example, in the defense that says I paid something that more than I made these payments he says I didn't make, you'd file a counter affidavit, and then you'd have to go to trial. But if absent something like that, you get in front of the judge and say, okay, the facts are undisputed, and based upon the undisputed facts, we are entitled to judgment as a matter of law. And that's how most foreclosure cases are resolved. The simpler way, I guess I should have this the opposite direction, is a default judgment, And that's where there's been no response, where the time after everything is served and the time to answer has expired and there's been no answer, you move for a default judgment. They didn't show up. They didn't do anything. They're not here. They didn't say, they aren't countering me. I don't even have to bother you, Judge. Here's my documentation. Give me a judgment. Done. Finished. And you go to sale. Okay? Oh, trial. The trials, what you see, again, sorry to do this, back to TV. That's where, you know, they play the funny music and they're in court and they're going back and forth. I can't do that. Anybody want to do the 2 notes, it's fine. But you get in there, you call witnesses. You get in front of the judge. These things are not jury trials because most loan documents would have a waiver. You get in front of the judge and you present testimony. You fly the banker in from Omaha, who sits there and you say, is this the promissory note? Yes. Is it in default? Yes. Judge? Okay. Defense? Have you lied on the stand before? You know, oh, nonsense. It's a trial. It's a literal trial. I'm making things up. And then you go through the trial, and assuming that the plaintiff proved everything and the defense can't refute it, you get a judgment and go down the road. Very rare are these things. You have to have a real commercial dispute over the allegations. Now, in a commercial setting, in a complex commercial foreclosure, sometimes it's not the non-payment that's an issue. Sometimes it's things like, you didn't pay the taxes. That put us at jeopardy, and we had to advance the money. You didn't insure the property. We had to go out and spend $300,000 to put windstorm insurance because it was June, and you didn't do it. And you're in default because you were obligated to do that, and not only do you owe us, not only are we calling the note, but you got to give us the $300,000 back and default interest on the $300,000 because we should never have paid it out in the first place. So that's non-monetary default, and that's going to all get proven in trial for the most part, as opposed to motions for summary judgment. If possible, that you could establish that in a motion for summary judgment if you have the affidavits and you show that the insurance lapsed because the bank gets a notice. The notice says this insurance policy expires on May 31st. And then you put that into evidence and you say we never got any proof of new insurance and therefore we laid out this policy and we incurred a $300,000 cost. Well, if the defendant comes forward and says, look, here's my proof I renewed this policy, and here's my proof that they showed them, and the bank screwed up, and the bank's not entitled to this, then you have a trial, then you have a problem. Because now you have a situation where the bank didn't have the right to foreclose, and they didn't have the right to force place the insurance.
Get those attorney fees back, no?
Probably. That's a whole next door.
Forced place insurance is...
Forced place insurance is when the bank places it because the owner of the property did not. And the bank has the right under almost every mortgage to do that because, again, here comes June, all right? June 1st, you know it starts June 1st. Hurricane season, correct. And so you want to have that windstorm insurance on the property. I had one exception to that rule. It was very interesting, actually.
Well, I've seen it. Is it possible, or I've seen it before, where the bank will automatically say your insurance that they started the mortgage with and accepted for the mortgage years later say this is unacceptable, we're forcing insurance on you?
Oh, I spent a week on this issue 2 weeks ago. Yes. It's not forcing it on you. It's the quality of the insurance and what you can get. You see, the problem is when the bank is located in Virginia and the bank's lawyers are in North Carolina, and they can't even spell hurricane. And now you get to the point where North Carolina's a bad example for that, but let's say they're inland. Now you get to a situation where now you're arguing back and forth between the borrower and the lawyers and the bankers at the closing. And this is literally what I was going through 2 weeks ago, where they wanted a certain quality of insurance and they wanted a certain maximum deductible. Well, if any of you have any insurance on any properties or even a home, you know that on windstorm insurance, it's a 5% deductible. And that's there because the insurance companies can't insure to $1 and stay in business. So they impose this 5% deductible. And it's a big hit to a property owner, but it's the only way the insurance can continue to function in an area that's prone to hurricanes. Well, This argument went back and forth with the bank because the bank says that's inadequate. Then there was the question of how much is the deductible. Then it's a multi-building facility. The deductible was per building. So they didn't like that either, because it was a very low deductible, but it was a deductible per building, and we went back and forth on the arguments with that. And this was a loan that my client, it was good for my client, it was a great deal. He didn't need the money. He didn't need to close this. He did have another loan he had to pay off, but they could have gotten an extension for an expense. But the interest rate turned out to be 3.58%, fixed for 10 years, interest only. That's a great deal. So it was in his best interest to close this loan. So the last day or two, we were arguing about the insurance and the types of coverage, and something called debt service coverage ratio, which I don't know if you've studied that in your other courses. Because he said, client said, what happens if we have another recession and the project goes down to 60% occupancy? And I'm still making my payments and everything is fine. I don't want you to default me just because you say I should have a higher debt service coverage ratio. We went back and forth and back and forth, and at the end of the day, they compromised. But those are the kinds of things, when you talk about insurance, why it's a real problem. Talked about the certificate of title. I talked about the deficiency. Any other questions on the foreclosure process? Okay. Now, I said we also deal with workouts. Deed in lieu of foreclosure. Very simply, can't make your payments, you go to the bank, you say to the bank, I can't make my payments, I want to give up. This saves huge amounts of money and a huge amount of time, but before the questions start to fly, because I get this all the time, you can't just mail the deed in. You can't just decide that you want to give up because things are bad and you can't carry the mortgage, and you can't just mail the bank a deed and say, I'm done. Because one of the key elements of a deed is acceptance. You can't just give it unless they take it. So that doesn't work. And trust me, when the things get sour, it happens all the time. Investors trying to get rid of the obligation think they can just mail a quitclaim deed and say, here's a deed in lieu of foreclosure, and we're done. No. So the most important thing from the bank's perspective is the title search. Because if the title is clean, if there's no subordinate liens, then it's perfectly okay to take a deed in lieu of foreclosure. The bank takes a deed, and just mechanically what they do is they receive the deed, they record it, they wait till they can update the title, and then they satisfy the mortgage. Or sometimes they don't if there's tax issues why they want to keep it open. But basically they release the borrower from any obligation. However, unlike a foreclosure action, a deed in lieu of foreclosure will not affect any subordinate liens. So, if there are intervening liens, I'm going to go back to my example of the hurricane windows vendor, the deed in lieu will be subject to those liens. And most of the time, the banks will not accept it. There are some situations where they anticipate a problem from the borrower, a fight, whatever the issues may be. They know they can resell the property, the subordinate lien, they determine it's a small amount, and they might take it and pay it and just add it to their expenses. So the deed in lieu of foreclosure does the same thing. It's the same title transaction, and just like the certificate of title, doc stamps are due on the amount of the debt. Because the consideration for whether it's a certificate of title or consideration for the deed in lieu of foreclosure is the amount that's owed to the bank. So they've got to pay doc stamps. You need to get the deed, just again, it's a title transaction, you need to get the deed from all title holders. So if you have multiple people, classic example, husband and wife are getting divorced. Husband's vanished, not paying the mortgage. Wife goes to the bank, oh, I don't want to get foreclosed, I don't want to ruin my credit, I want to start over, blah, blah, I want to give you a deed. Can't do it. She doesn't own it. She only owns, an interest in it. So you have to have all title holders. It also sells any foreclosure action sometimes. It's used for that purpose because if the property owner is raising various defenses, and now they deed the property back to the bank during the course of an action, all their defenses go away, and they can be dropped as a party. However, if you have subordinate liens or other issues, as we've been talking about, you can take the deed from the borrower that gets him out of the case, that's a troublemaker, and you can go ahead and foreclose on the rest of your liens. That way you can wipe them out and clear the title. That happens in a few situations. Commercial property with tenants. Remember, we talked about the assignment of leases and rents a little bit as a loan document. Under the assignment of leases and rents, the bank has the right to take, as part of the foreclosure action, to take the income from the property. And they have the right to go right to the tenants and say, tenants, we are now taking over control of the property through this foreclosure action and pay us the rent. Well, the other problem you have there is there's more to operating commercial property than just collecting the rent. Somebody's got to hire the gardener. Somebody's got to go out and take care of the plumbing issues of the apartment building or something like that. Whatever it is, you have to have somebody to operate the property. So the bank goes to the court and asks the court to appoint a third party called a receiver. The receiver steps in and takes over operations of the property for the benefit of the lender under the supervision of the court. The receiver collects the rents. The receiver pays all the expenses of the property. The receiver can even, with the right powers for the court, rent vacant space to improve the revenue. All the while the bank is going through the foreclosure process, or maybe working things out with the borrower. But if they're in the middle of working things out with the borrower, and the borrower has been bad throughout the process, you don't want the borrower in control of the incoming money. So you take it away from them, and the receiver does all. The receiver has to file accountings with the court. Everybody can see what the receiver does. It's completely transparent. It's good business for property managers to be receivers, but that's what they're basically doing. They're managing the property for the bank.
That was one of the questions on this exam for the cannabis. Wasn't it? One of the
Oh, she was talking about if, yeah,
case
That was the landlord taking over,
Right.
I believe.
right.
No, it's the assignment of rent.
If the landlord can access the property, I think was one of the
No,
answers.
it was if they would take over. if
No,
the
like
tenant
if
was in
the
default.
tenant
Over
doesn't pay,
operations.
if the tenant's in default.
It was a situation where if the tenant is in default, you can throw the tenant out. Can the landlord step in and take over the business?
No.
No.
No, because you have to be licensed to be in that business. The same way, it's bad.
Think about it, you could be a landlord, start putting marijuana, it's in default, and I'm taking over your business all day, every day.
Well, same thing. For example, let's say your tenant's a doctor.
So, yeah,
Can you evict him and start doing the surgeries for him? Anybody here got a medical
Play a
license?
doctor on TV.
When you spit that first slice and pass out, you're gonna know. Okay.
You also mentioned that when it goes to the cannabis industry, and the person, let's say for example, goes into bankruptcy or whatever, they have to take everything from the business and they have to leave, and the landlord cannot manage the business.
Correct. Well, in theory, anyway. The problem is with any business, and it could be, we've been talking about cannabis because it's more interesting, but in any regulated business, you can't just swoop in and take over. Big problem occurs, and you don't think about this, with medical offices. Doctors don't usually just go out of business and leave. They do, however, unfortunately die. I've had situations where the doctor has passed away, the landlord goes and there's medical records everywhere. You've got to do something about that. And why should the burden be on the landlord to have to do something about that? Because what you're supposed to do is basically contact all the patients and say, hey, we have your chart, would you like to pick it up, would you like to send it to someone? I think what is done in that circumstance is it's all given over to a state agency, and they take over.
Well, you can't, can you or can you not take over the prop, like this, the desk and whatever medical equipment that's in there?
Yes, but I'm talking about the patient charts.
No, I understand.
Medical equipment, well, it depends who has, unless somebody has a lien. Now, typically, the landlord's lien would be sufficient unless you have the MRI machine that General Electric has the vendor's lien on. Or, I think my example before was a leased copier. You always have those issues so that if there's somebody who has a superior interest to the landlord's lien, So yes, if any other sticks and stones, if you will, you can take over if it's done properly, but not the medical records and not the cannabis inventory.
How about, is it the landlord's responsibility if there's somebody like, I don't want to say the most best way, like say for instance something bad happened to a body, or is it the landlord's responsibility to clean that up?
No. The body?
Like say for instance something bad happened in the business where the landlord, like the tenant got killed or murdered, their whole staff got massacred.
Well, no, there's a separate people that come and clean first.
Police. You call the police.
I mean, after the cleanup, the police are only going to come and do an investigation with the body. But I mean, the bloods and guts on the wall and the
There are companies that come in and clean murder scenes.
That's actually an environmental issue. Yes.
Yeah, who pays for that environmental? Who's responsible for that? As a landlord, as the tenant, as a landlord.
Well, the tenant in your example is extremely dead.
You have to be.
Right?
Yeah.
So wait, are you going to send him a bill?
How about the tenants? How about say if it's like Walgreens or something like that, where their employees got, and Walgreens said we no longer want to be there no more. But Walgreens has a bigger corporation that can sue to clean that up.
Correct.
So
But I can promise you, in that situation, Walgreens is going to have someone come and clean it up.
Yeah.
You don't have to worry about that. When you talk about it, that is what's called in leasing a credit tenant. And you don't have to worry about a credit tenant in a variety of different situations.
but it's not a credit tenant.
So if it's not a credit tenant, now the question is there somebody left over?
Is there somebody left over? One of the business partners is still alive.
Well, then he's obligated under the lease to clean up the premises, to maintain it in good condition, et cetera, et cetera. I can promise you won't find a lease that says no blood. You might say no medical waste, you might say no hazardous materials, but somebody's got to clean it up. The landlord may engage a company to do it, but ultimately it's a tenant's expense. The question then becomes, anytime we answer that question, the question becomes, how are you going to recover that expense? So the landlord wants stuff cleaned up promptly. So the tenant isn't there, it's not the Walgreens, if it's a small company and there's one grieving partner left over, and he won't do anything because he's in shock. Now you hire the environmental company to come in, and you do it, and you pay it, and you clean up your space, and you send the tenant a bill. And you hash out how you collect the bill later. Typically, when you're dealing with damage, you want to protect your property. And if the person who's supposed to do it doesn't, you usually have the right under most agreements and most principles to protect your own property. And if it's supposed to be at their expense, you charge them their expense. That's how it works. So, besides the assignment of rents, we talk a little bit about construction loans. Construction loans are fascinatingly boring. But construction loans are more complicated than regular acquisition loans because what happens in a construction loan, the borrower has a project, they're going to build an office building, and they come to the bank to borrow the money. Well, right now you have a piece of dirt. So the bank is not just going to hand the $10 million to the borrower and say, go build the building and call me when you're done. What they're going to do is they're going to disperse the money as they see the money go into the collateral. Those are called construction draws. So each month, the borrower submits a request to be paid and proof that the money has gone into the project. The bank sends an inspector out. They see that its property's been cleared and the footers have been poured and the slabs have been poured. And so they say, okay, and they look at the thing and it says, this much for the slab and this much for the footers and this much for the Maserati. Oh, wait a minute, you can't charge the Maserati for this construction cost. So that gets taken off. And then the bank pays, and then pays to the borrower pays the contractors. Okay? If things go bad, the bank is still holding the money, but remember the bank's concept is they want you to take that collateral and resell it. It's very difficult to resell half a building or a quarter of a building unless you find another builder to come in, and that of course narrows the universe of buyers to take it from them. But if the bank has all the licenses and permits that go with the project and has the agreement from the contractor to finish the project, then it's much easier because now the bank can bring in another developer or another investor and say, here we have not only this project to build this office building, here's all the money which we will advance to in construction draws, here's all the permits that we have that the previous borrower got to build it, and here's the contractor who agreed to build it for this dollar amount, and we have these assignment documents, the assignment of the contracts and the assignment of the permits as part of the construction loan, that allow, where the contractor has agreed to work with the bank or the bank's designee to finish the project, and they can sell it and get the money out of it. Okay? So, banks are in the business of loaning money, and banks are in the business of dealing with the situations where people don't pay the money back. I've had a few of you ask me questions about purchase money financing, where you're dealing with a situation where the seller, either you are the seller and you're taking back paper, or you are a buyer and you've got the seller to agree to take back paper. The second is less risky for the person signing the note, but let's look at it for the provision of the seller. The seller's trying to, what? I'm sorry, no mortgage. I apologize, it's jargon. I should use jargon. You agree to hold a note and mortgage as the seller because it makes it easier for you to sell your house.
What'd you say? What'd you call it?
Paper, holding paper.
Holding paper.
It's just, you know, note and mortgage. Jargon like anything else. It happens all the time because, oh, I can make this great deal, and they're going to give me 10% down, and they're going to give me payments, and you know, I can sell my house right away, and I can't really get all that much in the investment market if I sell the house. Probably investment property here more than personal residence, but it happens in residents too. Because they can't take the money and invest it except at a very low rate, and this person whose credit is marginal is going to pay them 7%, and that looks really good to them. Well, remember, there's a relationship between risk and return, and you're getting that 7% because you're taking the risk. So what is the risk here? Well, risk number one is you're holding, if you were the genius that did this in 2006, and you sold the house for $625,000 and took a $530,000 mortgage back, and oh, you were so happy because now you were going to get your monthly pay, and you only paid $300 for the house anyway, but you made all this money and you're going to get paid this mortgage back and it's great investment income. Guess what? The market went, and all of a sudden the house was now worth $400,000. And you're holding a mortgage for $530,000. And the borrower looks and says, this isn't worth it. I don't think I'm going to pay the payments anymore. Okay, you're not going to pay the payments? Give me my house back. No, sue me. Okay, so now what happens? Now what happens is you have to go, as the seller holding the note and mortgage, you have to go and start a foreclosure action, which is what we were talking about earlier. Now you start the foreclosure action, and now you have a person who has made a decision to stop paying you, and they're not being very nice about this. I have physically seen what happens to a house when you get a bad person occupying who stops paying and who starts playing games. What kind of games can you have? Well, they trash the place. I have seen physically trashed houses. And I had one client, and they started talking about a deed in lieu, and the client said, well, I want them to pay me $10,000 for my troubles and expenses in order to take the deed, or I'm going to sue them. It didn't work out. The borrower didn't want to pay. They just wanted to say, and they said, screw it, sue us. And they trashed it. That's one problem. The other problem is the enforcement, where now you file the mortgage foreclosure and they put up a fight, or they do other things. They could, before that gets filed, they could file deeds to 3 offshore corporations, 2 minors, and 1 person who's mentally incompetent. Okay, so So when you go to file a foreclosure, you have to deal with all of those people and all of the different issues, and find the offshore corporation, and hire a guardian to take care of the incompetent person, and all of those issues have to be dealt with as part of that foreclosure. That's one possibility. And while that's going on, and while they're delaying it, one of two things is happening. Either this borrower, this owner, former owner, is living in the house rent-free and enjoying themselves in their house for nothing, or they have, what did you say? Rent-free, mortgage-free, either. They still owe the mortgage technically.
But they're not paying, right?
They're not paying anything. They're not paying the tax. Okay, so that happens, and the longer they can delay you, the longer they can stay. So they're going to file all kinds of weird things in the courts. They could file bankruptcy, because bankruptcy will stop a state court foreclosure action. And they'll go fight you in bankruptcy. Maybe the bankruptcy court will look at them and say, oh, well, you need a payment plan. So they'll take the deficiency, the unpaid payments, and they'll stretch it out. So now you can't foreclose, and you're obligated to take the back payments. Let's say they start making your regular payments again, but they still owe you 2 years of payments. And the court said, well, you can make the 2 years of back payments over the next 36 months. Good luck. All right? So, assuming that they can still pay. If they don't pay, and they don't pay the back payments as well as the current, you back in the process again.
It reminds me of a movie. You ever seen Pacific Heights?
I don't think so.
Michael Keaton, I think like Melanie Griffith, where they had this beautiful place in Pacific Heights. They ran into Michael Keaton, and he turned out to be the biggest scumbag ever, and stayed in there, didn't pay rent, destroyed the place.
In this case, art imitates life.
Yeah.
It's real. It's real. There's nothing you can do about it. It's what happens in the real world, especially in a downturn. Stay in there, they destroy it. I didn't talk about workouts, did I? So, workouts. Briefly, and it's not on here, so don't know why it's not on here. Briefly, I described a payment plan in bankruptcy. What was going on in the 2008-2009 period was the foreclosures would occur, all these things would happen, and you'd have modifications. You would have the banks sit down with the borrowers, because the banks didn't want to take the property back, and they would agree to a reduced payment over a longer period of time. They would take a 30-year mortgage and turn it into a 40-year mortgage. They would lower the interest rate, they'd give them more time. Maybe they'd give them some time to catch up and then go back to a normal payment plan. But they would do it so that the people could stay in their home, and yes, there were some government programs that helped with this. But the one thing they did not do, that everybody always wanted from them, was they would not write down the mortgage. They would not come to the borrower and say, okay, so you borrowed $530,000 from us. We're trying to help. We're going to change your mortgage to $400,000, and we're going to forgive you the $130,000. That's what borrowers wanted all the time. It did not happen. You know why it didn't happen and why it should never have happened? Because in reality, that borrower went to the bank, and that borrower got that $530,000 from the bank. They agreed. It wasn't the bank's decision to buy the house at the inflated amount. The borrower said, I promised to pay. And so the borrower is the one who owned the property, and if the property went way up in value, the bank wasn't getting extra money. But in this case, the property went down in value, and it's the owner's risk. So the banks were willing to stretch things out, but they weren't willing to forgive debt. And by the way, if there ever is a situation where debt is forgiven, either by a bank to an individual, or in an individual to individual, or even outside of the foreclosure or real estate, it's taxable income. So if you owe me $100,000, and I say, forget it, never mind, I don't need the money, I don't want the money from you. You just made $100,000 worth of income, and you have to pay income tax. So the zonk, if you will, happened when these people got foreclosed, and they lost their property to the bank. Now they're out the money, whoever down payment, they don't have their house anymore, and guess what happened at the beginning of the next tax year? They got a 1099 from the bank for forgiveness of debt income, or for a sale, if you will. If it wasn't even forgiveness of debt, for whatever that mortgage amount was when that foreclosure occurred, they got a 1099 and they sold the property for that amount. That's really what happened. It's a title transaction.
Can't they just like not file the 1099?
Who?
Doesn't the liability fall on the bank if the contractor doesn't do the 1099?
No. The bank files a 1099. The bank's the one that filed the 1099 against the borrower.
Oh.
And trust me, they don't forget.
They gotta write it off
No.
on cost for them, so they can
Sounds
split
good.
those.
Well, it's not a loss until they dispose of it.
But isn't that true though, like as an employer, if you're doing 1099s, that if your contractor, it doesn't fill out his 1099, it comes back to you? Like their liability?
You gotta give me more. You gotta tell me which side of the deal you're on.
So, essentially like,
You're paying me or I'm paying you?
I'm paying you.
Okay, so you're obligated to give me a 1099.
Yes, and then you don't do it.
No, you don't do it.
Okay.
If you're paying me, remember?
Like, let's say.
With your example, you're paying me.
The
Wanna turn
employer,
around?
the employer's gonna file the
The employer's gonna
1099.
file.
It's up to the person to file their taxes.
Right. If I'm receiving the money, the burden is on me to declare the income, regardless of what piece of paper you give me. If you paid me $10,000, that's income to me. I'm obligated to report that income on my taxes, regardless of what you file.
Okay.
So, I've heard some people tell me from the last recession, in certain states, it depends on where you were at, and how bad the area was.
Oh.
The banks were giving away the property. They were like, hey, if you sign, we'll knock off. You keep paying, we'll just drop your house to $100,000. This happened in like a lot in New Jersey. Like it was like really slum areas. And the banks were just like, and in some places in Miami too, in the foreclosure area, when I was doing deed loops, there were some banks were like, if they want to sign and start their payment, we'll knock it down to like $80,000. But that was because of the neighborhood. The bank was like,
It's unusual, but it's possible.
yeah, it was like it was in really crappy neighborhoods that they would give them that option.
Well, okay, at the beginning I said, the banks don't want to own the real estate. It's not their business.
Yeah.
They want the money back. Because their business is to take the money and loan it out again and earn interest on it. That's what banks do, okay? They don't want to own real estate. So, if they're foreclosing, and this is where I get to the workout part, if they're foreclosing and they see this property is going to be a burden on them because they're going to have to insure it, they're going to have to pay taxes on it, and they're going to have expenses to carry it, and they're stuck with it, they're going to sell it for whatever they can. And you know what? They might make a business decision to say, defendant, you already own this prime property. You already own this prime property. We're going to have to go, we're making a business decision that rather than go through all the expense it's going to take, if you, even though you owe us 150, if you pay us 80, not write the mortgage down, if you pay us 80,
Yeah.
we're done. You can take it and go do, so go somewhere else and borrow the 80 and get us out of this mess.
Yeah, that's what I've had that situation where
And you know what that's called?
short sale.
Exactly. That is a short sale. That was one of the prime workouts. And what happened was the banks would evaluate the property. They did appraise the property. And now you had an arm's length purchaser come along. And the arm's length purchaser said, this property is worth $100,000. Or $80,000, I think was
There's
your
been
example.
several short sales, but most short sales you have to do it arm's length.
Well, let me just describe it, because not everybody's had the experience. So now you have a property with a $150,000 mortgage, and the property is now worth $100,000. And along comes an independent, third-party, unrelated, unconnected buyer, arm's length. It's not your brother-in-law, it's not your lawyer, it's not your buddy, it's an investor. It's a third-party arm's length, and says, I'm willing to buy this property for $100,000 as is. Now you go to the bank and say, bank, here's the appraisal, here's what the property is worth. I've got a real person that's willing to pay that. Bank looks and says, I don't want to take this property. Even though I'm owed 150, I don't want to take this property. And he looks at the borrower, and the borrower's got nothing. So you can't sue the borrower for the deficiency because he's not going to get anything. the bank makes a business decision at that point, because they know if they go through the foreclosure process, they're gonna have 175 in at the end of the day, and they're still only gonna get 100 if they're lucky. So they make a decision to take less than the full amount of the payoff, and that's called a short sale. They're taking a short payoff. They're not making a short sale, they're accepting a short payoff. The moniker short sale was applied to the transaction where the borrower was able to sell the property in a regular transaction and pay off a short payoff. There are restrictions. Beside it being arm's length, the banks will typically require that the brokerage commission not exceed 6%, which is a normal commission. They're also very strict about not allowing the brokers to participate. There's also problems with second mortgages. I mean, in that situation, there could be a second mortgage, and the second mortgage could be another $30,000. Well, the second mortgage knows they're going to get foreclosed. And they don't want to be involved with it either, because they're never going to get anything out of it. They might in some cases get $5,000 to sign off. Sometimes that happens. Sometimes they sign off for nothing. But everybody gets around the table, works it out, the property gets sold for the current fair value, the bank writes off, takes a short sale, and the new buyer goes down the road with new financing. The unfortunate issue that you don't think about in all of this is, whose money evaporated? The banks, but banks are owned by people. Somebody's money evaporated. That bank wrote a check for $150,000 for that borrower to buy that property. That money's going away. Your question?
Yes, but I have like a bunch like in my head right now. One of them being.
We'll leave them there.
Have you ever heard of? Okay, I remember. So a short payoff. If you speak to a bank and you use like the phrase short payoff, it does like it means something different to them than if you want to do a short sale.
I just told you that.
But now you
There's
said
different sides of the transaction. A short payoff. If you own the property. In my scenario, you borrow $150,000, and you say to them,
I want to do a short
I want to pay you $80,000 because that's all the property is worth. They're going to show you the door. Because why should you benefit to their detriment? You're the one that signed the piece of paper that says, I promise to pay $150,000. You took the money and bought the property. You made the decision. If you are giving up, and you're not benefiting, because you're not allowed to take any money out of a short sale.
So if you don't benefit, then that's what a short payoff is?
Short sale.
So then what's the difference? Because I don't understand the difference.
Well, from which side of the transaction it is. So a short sale is the transaction generally. That's the transaction we're describing. The short payoff is what the bank is receiving. That's all.
So I've heard like also like some of the transactions that I've been a part of, like the debt will have been bought up by a third party, and then they're trying to just collect whatever they can, and then from that point on you're negotiating a short payoff, but then it's not a traditional short sale, and then is that different?
There's all kinds of, yes, there's all kinds of complications, because sometimes the bank, banks buy and sell notes and mortgages.
Yeah, like notes that they don't want.
Right, because they have determined that they're not going to get paid.
Exactly.
So what they do is they sell it for 30 cents on the dollar as part of a big disposition of things.
Mm-hmm.
Aqua mortgage, aqua mortgage, penny saver.
All kinds of, it's junk money,
Yeah.
It's junk paper, which means mortgages and notes that are not going to be collected at full value.
And then
So they get rid of them. So now you get Joe Investor coming to you.
yeah.
Joe Investor's paid 30 cents on the dollar. Joe Investor comes to you and now gives you an opportunity as the property owner to pay him 50 cents on the dollar, which sounds like a great deal to you
Yeah.
because you're saving on your payoff. That's a true short payoff, because now Joe Investor's still making the extra, the spread between the 30 cents and the 50 cents all day long.
Okay.
He's happy, you're happy, the bank has already taken care of their sadness,
Okay.
but they're not dealing with you on giving you what Joe Investor is willing to give you.
Well, I'm still not seeing the difference, because on a short sale, the seller's not benefiting, and then on a short payoff, the seller's not benefiting. So,
Yeah,
like,
well,
what is
so-
the
No, on
difference?
short benefit they are in my scenario.
Who is?
The short,
In the short payoff that we just talked about, where Joe Investors acquired it and now you're still you keep the property and
the
you pay it
bot,
off
the
the short
seller,
number.
the seller,
It's
loan,
not common.
here, the lender is not benefiting on a short payoff, but on a short payoff, the person that owns the property that did the loan gets benefits. They're actually eliminating their debt and still keeping the
And
property.
keeping the property.
Well,
On a
the
short
bank's
sale-
benefit of not keeping the asset.
But they've already
Yeah.
sold the asset.
On a short
Now,
sale-
we've gone to a different scenario here, where the bank has sold the asset for 30 cents on the dollar.
Oh,
Because they,
yeah.
bad loan,
Yes.
bad collateral, we're getting rid of it, the guy's got bad credit, the property's, we're getting rid of it, we're getting it out of our portfolio, and now Joe Investor has it.
So
And
because
then what about like relocation assistance and stuff like that?
Forget that.
Or like,
That's-
or like you buy, I know, I've heard other investors doing this, I don't do this, I don't like short sales, but like, sometimes like they'll do like a short payoff, like they'll buy it from someone else, and then obviously they don't wanna pay the seller, because they're doing a short payoff or short sale, and they'll buy like a car or furniture from them as a way to like pay them, obviously, for allowing them the short sale to go through. Like, what is the legitimacy of that?
you can't.
That has no legitimacy.
You can't.
Well, I mean, like from like strictly like legal, like you're
This is
saying
how
like
you-
that's illegal. Is that not
This is
illegal?
how. This is
It's
how.
probably, because, wait. So, in that circumstance, when you do a short sale,
Mhm.
there's documentation that you give to the bank that says, I'm not benefiting from this. I'm not getting anything from anybody. I'm not getting anything from the buyer. I'm not getting any kickbacks. I'm not getting anything from anybody. I'm walking away. And that is the inducement to the bank for taking a reduction in what they're entitled to receive. Okay?
Because sometimes you can buy a short sale, obviously low enough, so in which you can still make money as an
Wait
investor.
a minute, Joe.
So-
Let's hang on. You are trying to work deals and transactions here. We're talking about legal principles.
No, exactly. But that's an important
So let
piece,
me answer
because
this question.
if you're involving like, okay, so a seller is defaulting,
Right.
and they want to do some type of short sale, and it makes sense for the bank to accept that short sale. But as an investor, for you to purchase that short sale and be involved in that transaction, like as a buyer, like, hey, we want to do a short sale, we already have a buyer that's willing to pay cash for it at that price, like let's make that transaction go quickly and smoothly. But as an investor, as an incentive for that person to go forward with the short sale as opposed to just lose it, because most of the people that are in foreclosure are like,
Proper.
Let me
It's
tell you how.
improper.
what do you mean, what's improper?
Let me tell you how.
Stop interrupting my guy.
I'm just trying to tell you how to do it. So
You don't know though, you're not
I
a
do
lawyer.
know. So I'm
You
gonna
don't.
tell. Okay, so
So
let me explain
let
to you
him-
how it's been done in the past.
Hold
I'm
on,
gonna tell them how it's been done. in the
Just hold up, may I?
past. Yeah.
Unless you want to come up here.
I'm just saying. I was telling how it's been done in transactions in the bank.
I got it.
Yeah.
So they had me here for that.
Yeah.
Okay, the stories are great, but let me answer the question, okay? It's improper. Everybody's signing contracts as part of the transaction that nobody's kicking anything to the seller,
Mhm,
okay?
mhm.
Maybe you've had them under the table?
No.
Okay, so it's improper. It is documented improper. You're back to bank fraud, okay? Plain and simple. What may actually happen, we don't want to know, all right? Bank fraud. The whole idea, the whole concept where the bank is agreeing to take less than what they're owed is the seller does not benefit at all. Now, the only possible exception where this, and I know you and I talked about this privately, but the only possible exception is there's a situation to get rid of the seller so that the bank can get rid of this property, this debt. There's something called cash for keys. And with cash for keys, in order to get rid of the person in possession, the seller, the bank is actually going to pay a little something to the seller to go away and to not fight.
But isn't that deed in lieu?
But it's in addition to the deed in lieu,
So like to vacate the property.
yeah,
Okay.
to not put up the fight. Okay.
So in short sales, what we have done in the past to evade that, when you make the offer from the investor, what you do is you put in the offer for the moving cost. So if you say that the seller needs $5,000 to move, so I'm making the bank an offer of $135 and $5,000 out of the money that I'm paying the bank needs to go back to the seller to move. That's a legitimate way of taking care of that issue. So
Exactly. But let's say
As long as it's disclosed.
it's disclosed.
As long as it's disclosed, but it's technically, that's a lot of money, but it's technically, that's not money going to the seller. It's going
Going
to
to the mover.
So to the mover.
And so in that exact scenario, that would happen, but then let's say like the seller would get cold feet, like, I don't care, I'll just take the foreclosure on my credit, I don't care, like.
Right.
But then the investor who's purchasing the short sale has a lot to lose, because let's say that he has, you know, whatever he has invested and he wants to make money.
Okay.
So, like now, obviously I know confirmed, it seemed to look whatever, I've heard of investors saying like, I'll buy furniture from you for an additional 20 grand
It has to go to the bank.
but outside of closing.
Fraud.
Okay.
Now, what you do is you take the moving expenses and you move it to another location and sell it. You're still committing fraud on the bank, because it's still winding up in the seller's pocket. So everybody's committing fraud. Okay? That's all.
That's all.
That's it. I mean, legal conclusion. There's not much you can do to color that.
Yeah.
Because if any consideration being paid to the seller has to come in from the short sale, then I can promise you, that bank that's taking a hit of $50,000, $60,000 on our example is going to be very unhappy hearing the seller got $20,000 for the used furniture. Very unhappy. And they're going to go after everybody.
They can cause you to lose that investment.
I mean, you could go to jail for that, right?
Bank fraud.
Yeah.
Yes.
Yeah.
Federal. Big bash.
Yeah. And so, and
Or it's like they said, or it's like Attorney General Rhodes said on Billions at one episode, said, when you make a federal case out of it, there's no parole. You know, you go in there and whatever I give you, whatever sentence the judge gives you, and I go for the maximum, that's what you're going to serve. This is federal. So yeah, you don't fool around with bank fraud.
And then there's something called surplus, right? Where
Okay, surplus. So rare, much more rare, but it does happen. The opposite of deficiency. So when I went through that whole scenario in a foreclosure case, and at the end of the day, the property didn't bring in what was due to the bank, and the bank then went after the borrower who signed the note for the difference, that's called a deficiency judgment. Occasionally, and it is much rare, now maybe in an upmarket with a peculiar situation with a foreclosure, it doesn't usually happen. Now we get back to we're going back to the foreclosure judgment. Foreclosure judgment is $1,050,000. Well, expenses and costs on a $1 million note. And now we go to the courthouse, or to the real foreclose, and we have the auction, and it's a good piece of property. It's got good tenants, it's got development potential, it's something somebody wants. And somebody goes to the courthouse or to the foreclosure software, and they bid $1.3 million. The money gets paid, they get their certificate of title, the money gets put into the court registry, the bank has a judgment for $1.05 million, plus whatever their expenses were, plus their attorney's fees, that gets paid to the bank. Now you have a few $100,000 sitting there. What happens to it?
goes to the seller. We have to claim it though.
If there's subordinate liens,
I'll go to them.
let's go back to the Hurricane Window Company. So they have now hopefully filed an answer in the foreclosure when they got served saying something to the effect of, we admit that we're inferior to the mortgage, we are owed X dollars for our claim of lien, and if there is any surplus, we reserve the right to participate. And so the junior lien holders will receive the surplus in order of their priority. And then if there's anything left over, it goes back to the borrower. Because ultimately, it's the borrower's property that's being taken away. Why that would occur as opposed to a straight up sale of the property? Because you can do all of that through a closing for a lot less than time and expense. And if the property is worth more than what he owes, it's unlikely you're going to wind up in foreclosure.
Can you repeat where the surplus came from?
So at the public auction, the property sells for more than what is due to the bank. Okay? More? You're exceeding your allocation. Go ahead.
About an owner's policy. So, like, let's say you're buying a really good property for 50%, 60% of what it's worth. When you go and you get an owner's policy on like title policy, do you get it for what you're buying it for, or do you get it for like an inflated price so that you're covered on the occurrence that anything happens?
There was a question on today's exam that the question was, which of the following does a title policy not cover? Anybody remember the answer?
Yeah.
value, the insurable interest, what you're insuring is only what you're paying for.
What did you say? One more time?
Title insurance is for the purchase price. Okay? You can get more title insurance if you can support it with an appraisal, or if you can, let's say, yeah, support it with an appraisal and pay a higher premium.
Are you talking about title insurance or other insurance?
He said title insurance, he said owner's policy.
Oh, okay.
Yeah, someone said that if you're getting a supreme discount on property, that you should essentially try and get an owner's policy for what they get appraised.
To what end?
Yeah.
Why?
No, exactly. I don't know.
Why would you do that?
I don't know. So I'm asking.
You gotta have a reason. You're spending two
So that if
elements
anything
of
was to
extra
come,
money.
because if anything was to come back, then the owner's policy only covers up to what you paid as opposed to what it's worth. So now you're in the hole.
Well, now you go down the road, okay? And the property does increase in value, and you go to refinance it or something. When you refinance it, you can get an appraisal, and you can increase your title insurance. But I'm going to tell you, in your scenario, you're at the closing table, and you're paying $50,000 for a property you think is worth $100,000, and you pay the extra money, and it shows that you're buying title insurance for $100,000. You're going to upset the seller a little bit.
Probably.
You're on the closing table. I'm not sure you can do what you're suggesting at closing. I know you can do it in connection with another transaction where you have it appraised.
It sounded odd. That's why I didn't.
It is very odd.
Yeah, I didn't know.
But why would somebody want to do that? Why would somebody want to up their insurance
Oh,
policy
okay.
on their title insurance?
Late down the road they would. So let's say, I'll give you an example. Let's say you buy that crappy property. The one that's, in a terrible neighborhood or it's in terrible condition or whatever it is. And now you start spending money to fix it up. And now because you fixed it up and you actually put cash into it to put on a new roof and add a couple of bathrooms and maybe put an addition on the property, now that property instead of being worth 80 is worth 140. And you put real money into it, okay? So now you want to make sure that if there's a title problem, you are protected for the additional value. So now you can go get an as-built appraisal with the improvements on there, and if the appraiser says it's worth 140, now you can go and increase the title insurance and pay a premium.
But this is what I'm trying to put at. If I purchased a house and I got a general warranty deed with the title insurance, and I've owned this property and I updated it all these years, what would give me a quality title from the new insurance policy?
Probably nothing, but you never know. Probably nothing is the answer. But you don't know until you go to, you don't know that you have a claim on your title insurance until you go to resell it or refinance it. So now what happens is you've owned the property for 20 years. No, you've owned the property for 6 years. Okay? You got that title insurance policy, you've done it, everything's fine, you have no issues, you've owned it, there's not going to be anything wrong with it, right? Time to sell and make your profit. I do my title exam, and my title company finds that there was a problem that the other company missed.
But the other company covers it.
Only to the amount of that policy. Now, the chance of your policy, the chance of a complete failure of title is slim. It's more likely an encumbrance of some sort, but it's possible. It could be that the person that signed your deed wasn't the person that owned the property. Could be. I have one situation where
But I'm still covered with the first title insurance policy.
only to the purchase price you paid for it.
You just put 30 into it, so now you're into it.
You have a face value in your policy.
So, but the person that's coming after me cannot come after me if it's for the first transaction. They only come off the face value of the first transaction. Nothing matters beyond the point. The
You don't own it anymore. You never owned the property.
What? So then,
Hold on.
hold on. So then if I never own the property and I signed, then the policy insurance covers me
Right, for how much?
for the amount of money that I put in the property.
Correct, but now now you've lost your profit. You've lost your 7 years of increase of value. It's gone. You don't have any right to it. It's not your property. All you did was you bought the original policy amount. I mean, it's unusual. This is really like a little out there.
Yeah, that's what I was saying.
But theoretically, theoretically,
But would the title company be on the hook for that?
to the amount of the face amount of your policy. That's all they owe you. You're out your difference.
Moving on.
Yeah, moving on, alright. I'm
Okay.
exhausted for.
Tenants, evictions.
Question from when I left.
Evictions. What is an eviction? That's an easy one. Pay the money or we throw you out. It's the removal of persons who are in possession. See that? That's real. That's like very simplistic. The second part is more important. An eviction requires a landlord-tenant relationship. What does that mean? Well, there's other reasons to be in possession of property. Any of you residential brokers ever do an early occupancy agreement?
Post occupancy.
Post-occupancy, almost as much fun. So what happens is, now you have a person, I'll take the post-occupancy, that's fine. Now you have a person who has sold the house. They got all their money. And they've agreed to, that they're allowed to stay there for 30 days while the new house is being finished. And the 30 days comes and the new house is not finished. And the buyer comes and says, 30 days is up. And the seller says, sorry, I have no place to go. Yeah, but I gave you all the money. I'm sorry, I can't move yet. Give me another 2 weeks. 2 weeks, our lease is up, we gotta move in. I'm sorry. Okay, so it's not an eviction in that case. Why? Because it's not a landlord-tenant relationship. It's a post-closing occupancy agreement. That is a beast. It is a nightmare thing. It is a continuation of a contract for purchase and sale. And it is not a landlord-tenant relationship. You could theoretically, if you wanted to really do it the right way, call it a lease and actually create a lease. And the benefit is that it's a little bit easier to evict because the landlord-tenant statutes are easier, but it's all governed by statute. And in fact, in some of the materials I gave you, and you have it in today's materials that I posted, so you have it twice. You have a copy of Florida Statutes, Section 83, Chapter 83, which is the landlord-tenant statute. And it's very, very carefully restricted as to what you can do in a landlord-tenant relationship. For example, non-payment of rent. You are required, as a prerequisite in a residential eviction, to serve a 3-day notice. A 3-day notice says, pay or deliver possession. I believe I gave you an example of a 3-day notice in the materials, hopefully.
So and you can do that 1 day after they don't pay.
Absolutely, unless there's a grace period in the contract. But yes, 1 day. And it has to be as the statute says. In a residential eviction, you cannot vary the 3-day notice.
Not vary?
You cannot change it. You cannot decide you want different words in there. Okay? I believe they've softened the statute and put in the word materially the same. But for example, if you look at the 3-day notice, you'll see that, wait a minute. Make it easy.
So a quick question, in the post-closing loan, the post-occupancy closing?
Post-occupancy agreement.
Okay.
That is-
So if the person's there 2 weeks after the 30 days, the buyer has no recourse?
No, but it's a different cause of action.
Okay.
I'll talk about that in a minute. Oh, here. See, I'm trying to give you fun things. Okay. So this is a 3-day notice. It's an old one. And this is pretty much what the statute says you have to say. That you're notified, you're indebted. How much? Demand is made for you to pay the rent or give possession of the premises within 3 days, excluding Saturday, Sunday, and legal holidays, from the date of delivery of this notice. It used to be, and without looking at the statute, I can't tell you that it's been completely fixed, that this would be deficient. And I had a client who used this very form, and there's a lawyer who represents tenants, and whose specialty is finding deficiencies like this one has, and holding up and moving to dismiss the eviction. And by being invalid, yes, also possible, but it happens all the time, and it's an industry. He gets attorney's fees. Because the landlord, now this would have not been prepared by the lawyer, this would have been prepared by the individual landlord that doesn't want to pay the lawyer. So what the client did was, see where it says 3 days from the date excluding Saturday, Sunday, and legal holidays from the date of delivery of this notice? The statute goes on to say to wit, colon, and there's a place to put the date in there. Okay? Well, the client said, I don't want to make a mistake figuring the number of days and putting a date in there. I'm just going to take that out. Can't do it. Well, but then you can, I do believe the statute's been softened. Guy filed it. This is a prerequisite. This is important. This is a prerequisite to filing a residential eviction. You have to give this notice. And in commercial, while it's not statutory, you'll never get in the courthouse door without showing the judge that you gave this kind of a notice. In any lease, residential or commercial, you can make it longer than 3 days. You can provide a written notice for non-payment can be longer. You can most commercial leases, unless the tenant has had a lawyer arguing for them, have no grace period and no written notice requirement. That if the rent is unpaid for 3 days, 5 days, 7 days, whatever it is, boom, they're in default. I argue for 3 days written notice or 5 days written notice, whatever the number is to agree upon, with a proviso to make the landlord a little happier, that if the landlord has to give 2 notices a year, because it's a chronic defaulting tenant, the notice requirement goes away. But you can't do that in residential, only in commercial.
Quick question, so you said the date had to be on there? So
Yes.
that's the date, that would be the 3rd day?
So it's up to the landlord to compute how many days, excluding Saturdays, Sundays, and legal holidays, and put a date so that the tenant, who doesn't have the brains to write the check for the rent, can know what day he has to have that money to the landlord or be out. Oh, the other deficiency in this notice, it doesn't say where the landlord's address is. Where am I taking the money? What am I doing with the money or the keys?
I'll be standing outside your place. But does like time of the day matter? So like I delivered at 8 p.m. and then there's 3 days from them, or is it 1 day is 8 p.m. the next day?
An account like this excludes the day of delivery.
Okay.
Well, what he's saying is the time, suppose it comes at 10 o'clock.
Right, but it
10
excludes the
p.m.
day of delivery, so
Anytime the day of delivery, it's 3 days after that. Now, except here where it's excluded by statute, Saturday is a business day for most calculations, unless the contract says otherwise.
So you mentioned the 3-day notice to pay rent or the reposition is a
Prerequisite, you must do it or you cannot file an eviction. And if you do file the eviction, then you'll get Simonized.
So you really,
Chuck Simon is the name of the lawyer, somebody I grew up with. Actually, he had to practice in Fort Lauderdale, and this is what he was doing. I'm almost sure, I'm going to take a look for you.
I thought you were talking about an infomercial. Sounds like some product, I don't know.
It does. It very much sounds like a product.
so if you put that your inspection period is based on business days, it actually includes Saturday?
Depends on the contract will define it usually.
Well, if that's like an
It depends for certain things. Like for example, residential lending, residential refinance for a right of rescission, 3 days right of rescission, it does include Saturday.
What if you're collecting rent with Venmo on that thing? Like all your tenants pay you through Venmo
Or through ACH.
or that?
Venmo's a brand. Yeah, so what?
Then you don't need an address. I guess you would need,
Where do you drop the keys on?
oh, if they want to leave, I guess.
See, it's a choice.
Yeah. Oh,
The keys in the mailbox.
the PO
Whose
box.
mailbox?
The mailbox of the property.
That's not delivery.
And put the address?
So you have to
You
get
have to put the location. I wonder what.
Bear with me a second. Let me see.
Drop the keys in the mailbox.
What if there's none?
But what about you need to drop the key for the mailbox? How are you going to close the mailbox?
Never close the mailbox. I know we don't have mailbox.
It's actually,
It's illegal to go into the mailbox, right?
You know,
actually, technically that's true.
It's federally.
Paul makes a good point. You can't use the mailbox for private use. The mailbox belongs to the post office, it's only for the post office. Bear with me a second, I want to see if they've changed this. And again, the statute, which you have, this is posted in your stuff. The statute is divided into residential and commercial. So you have different things that you have to do in residential, much more stringent. I think we talked about security deposits and such. But I really want to, this 3-day notice is something that you may actually encounter in life. I should probably go with this, I don't do this enough.
If you control that,
Is that like a standard form that you can find on some type of like,
What form?
like a 3-day notice?
It's in this statute. Here it is.
Oh, the actual forms?
Here it is. Look at the words.
Ah, I think you.
Okay? If the tenant fails to pay rent when due, and the default continues for 3 days, excluding Saturday, Sunday, after delivery of written demand by the landlord of the rent or possession, the landlord may terminate the rental agreement. Legal holidays for the purpose of this section shall be court-observed holidays only. All right? You can't, Groundhog Day doesn't count. 3-day notice shall continue. Okay, this is where the statute changed a few years ago. The 3-day notice shall contain a statement in substantially the following form. So, and you see it ends with landlord's name and address? So they're basically setting forth all the required information that you have to have there. It used to be, without that substantially, it used to say in the following form. So that's where they were clipping the landlords who left a word or two out or did something. All right? I want to make sure to go through that. The other thing, well, again, I'm not going to read the statute to you here, but I'm going to tell you there's another provision. So, what used to happen was you filed this 3-day notice, you filed the complaint to evict the tenant for non-payment, and the tenant would start filing defenses. Well, he didn't fix the toilet, so I'm not paying the rent because he didn't fix the toilet. Or he told me there were 3 bedrooms, and the second bedroom was half the size he told me, so I'm not paying the rent. Or some nonsense like that. Whatever, I'm just making things up. So there's a statute that says, and it's been in the residential statute for quite a long time, that in order to maintain a defense other than the payment of rent, remember I said you could file an affirmative defense, and the affirmative defense to an eviction would be, I paid him, here's my proof, I Venmo'd him, and he received it. Okay, I'll bring it to the modern world. The landlord, oh, I'm sorry, Judge, yeah, I see it here, I didn't know it didn't get posted to my account, or I didn't look at my bank statement. I was waiting for a check in the mailbox. So, that's the defense, that's legit. Other than that, if the tenant wants to raise any defense other than non-payment, the tenant has to pay the rent money into the court registry. Which means, go to the clerk's office. And by the way, if you can't figure out what the rent is supposed to be, in residential you should be able to figure it out if it's right there in the lease. That's what gets paid. So, early in my career, I don't want to tell you the year because it's a long time ago, I got onto the landlord-tenant committee of the Florida Bar. It's something I've been doing my whole career because it's something I enjoy. And I'm looking at the statute, and I said to them, you know, we have this statute in the residential side of the Landlord-Tenant Act that says what I just explained to you, that you have to pay the money into the court registry. I said, we could really use that same procedure, much more so in commercial. Because in commercial tenancies, there's much more opportunity to play games and to file things that the landlord supposedly has not done. And I was relatively new on the committee, another committee member said, hey, that's a good idea, write it. So I looked at the statute, which basically said in connection with the eviction for non-payment of a dwelling unit, blah, 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 blah.
So you just said commercial, boom.
I took dwelling unit and I crossed it out and wrote real property. I said, here. Well, then it went to committee. And we happened to have had a county court judge on the committee, and the statute got expanded and expanded. We got it through, we got it passed. So what happens is, the Florida Bar substantive law committees like that will write and propose a statute. It gets approved by the leadership of the bar, and it gets handed off to the bar's lobbyists and presented to somebody in the legislature who sponsors the bill. And assuming it's not controversial or it's something good, it'll often get passed by the two houses of the state legislature, signed by the governor, then it's a law. The expansion of my two-word change became a whole provision where you could, the tenant could file a request for a hearing before the judge to determine the amount of the rent. Because in a commercial lease, remember we went over all the components of rent. You have base rent, percentage rent, common expenses, all those things are rent. So you could have, if the landlord and tenant are sniping at each other, which is common, you go before the judge and the tenant says, how much do I pay? And the landlord proves it up. The judge says, okay, agrees on it, and now the tenant is directed to pay that full amount to the court registry. If the tenant does not, boom, judgment for eviction, out. Now you go down the road and they're fighting for a month or two. Now the landlord goes back to the court and says to the judge, we're fighting over he's claiming the roof leaks, I'm claiming it's fine. He's claiming there aren't enough parking spaces, I told him there's enough and there are enough. All these things. I need the rent money because he's still in there and we're fighting and he held it back. And while we're fighting, I have to still make my mortgage payments and pay my expenses. And so the court will agree to disperse the rent money in monthly installments if there's a legitimate fight going on. And that's how the procedure works.
No, is this residential and our commercial or both?
Both. Okay? We got to that through, right, okay. Go with the statute.
Do they do order of show cause down here?
Yes, in foreclosures.
Not in landlord tenant court?
No. Okay. The other thing that happens, I'm getting there. The other thing that happens, judgment of foreclosure. So you get down to the eviction process. Sometimes, in most smaller cases, the court will send you to mediation. They will tell the people to go in front of a neutral party and they'll try and work out the difficulties. In an eviction, where you're talking about payment or non-payment of rent, it's a little difficult to mediate because what are you fighting over? You're fighting over something, but if you're fighting over the rent, there's nothing to mediate. In most small claims types of things where it's not an eviction, they will send you to mediation. So now you get past all this, you get to the point where the landlord has proved that the tenant has not paid, the judge enters a judgment of eviction, and boom, the judgment says, get out. You lose, get out.
And if they don't, then the sheriff.
Then you go in front of the sheriff, and you have the court issue to the sheriff a writ of possession. And the writ of possession says, you are hereby commanded to post a notice, blah, 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 telling them to get out within 24 hours. And if that doesn't happen, then the sheriff will stand by and keep the peace while you remove the tenant. The sheriff does not operate a service to remove the furnishings and furniture. People think the sheriff literally throws you out. That's not what happens. The sheriff stands by, they fold their arms, they wear their green shirts, they have guns, and they stand by while your moving company throws everybody's stuff on the lawn, or whatever, the landlord. Hopefully by that time, the tenant moves.
And then the post-occupancy, you said you.
Okay, that's called an ejectment.
But you said you suggest actually doing a 30-day lease?
Because it's an easier process to remove somebody.
How do you put ejectment?
Ejectment.
What if in the agreement, so, like you said, someone pays and then they give a post-occupancy agreement for 30 days, but what if they just hold back like $10,000 or $5,000 of the purchase price? Then like it would be much more incentivized for that person to remove themselves. Yay or nay?
Incentive is yes. I agree with the incentive statement.
But
However, if you've got no place to go,
well, then you do the ejection and then you just made $10,000.
great. You're the investor again, right?
Yeah.
Okay, what happens if,
Or the home buyer. The home buyer.
the home buyer's on the street?
Oh, I guess that's true.
The home buyer's not in business. The home buyer doesn't, you're the investor, you don't care. You want to make your 10,000 and then you'll rent it to somebody else. And if you have to find a different tenant because your new tenant walks on you, you don't care,
All right.
okay?
Yeah.
If you're a home buyer and your stuff's on the truck and the kids have to start school,
It's so true.
you got a problem.
Okay.
And nobody wants that. I typically advise against those agreements. It happens. I know somebody, I didn't handle this transaction, I think the house was $17, $18 million. But I think they did a lease back. I think they actually did a lease.
Question.
Yes,
You spoke of the writ of possession and
Yes.
lease, but you didn't speak of it after foreclosure.
same thing. It's also a writ of possession if they don't get out. You
You
have
have
to,
to wait for the certificate of title to
Yes.
possibly.
correct.
What was your question? If it's what?
After the mortgage foreclosure,
Oh.
and you've lost title to the property, and you don't move. It's the same thing. You get it. There's a writ of possession, it's virtually the same writ. Same thing, the sheriff goes out.
Yeah, but the person owns the certificate of title applies to the writ.
Okay, so the certificate of title is basically a deed. So now the deed goes to the person that was a successful bidder at the auction.
And that's who has to do it. What I'm trying to point out is the bank doesn't do the writ after you win it. You
Correct.
have to, if you win that, you
Correct.
have to go and do that
Well-
whole process.
Yes, that's true.
If they're still living there, or somebody's still living there.
Right.
If there's nobody living there, then you can just retire, you can change the keys.
Yeah,
That's
oh,
it.
sure. Yeah. Very easy to take possession of vacant property.
It's very,
Vacant.
but everything is yours.
I'm losing people.
It's that time.
I don't want to hold you to the very end, because I was going to take a fast break myself, but I don't want to do that and keep you here. I can work this into more stuff next week, if that's okay. That where we're going? I see dozing, I see quietness, and I'm trying to be kind that way.
Thank you.
Look, I know you've had the morning, and I know you had the test, but I'll try and pick up on a couple of extra things on the real estate litigation that we missed out on, because some of it's good stuff. And then we'll go into whatever the next unit is. We'll go ahead and put it down. No, that's okay. I'll tell you what, I'll make you a deal. I'll make you a deal. I'll be right back, and then I'll answer questions. And then my patience will be much less. Somebody want to kill that? Please? If I kill it, I can just turn it off.